Hey guys, welcome back to part 2 of our interview with Ms. Saltanat Imanova, the chairman of the Supervisory Board of the International Arbitration Court in affiliation with the Chamber of Commerce and Industry of the Kyrgyz Republic. If you have missed part 1, I would recommend that you watch that part first, where we spoke about the International Arbitration Court and the role it plays in the Kyrgyz Republic. Now, coming back to our discussion about the International Arbitration Court, Saltanat, is it mandatory for a company to trust their disputes to be handled by the International Arbitration Court in the Kyrgyz Republic? And tell us also, what benefits do they derive compared to leaving the disputes in the hands of the state courts?
No, it is not mandatory. Parties may use arbitration or mediation only if they agreed in advance to subordinate all potential conflicts and disputes to be solved by the arbitration tribunal or by the mediator. The main advantage of arbitration is the reputation, and also mediation is the reputation and professionalism of arbitrator or mediator who solve the dispute, and the high quality of services they used to provide and the institution used to provide. I believe the main benefit of arbitration and mediation is the parties' willingness. If you see every article of the arbitration rules or arbitration law, you may see the first sentences of each articles. If the parties agreed, unless the parties agreed otherwise, it means the parties, not arbitrators, are those key players in the arbitration process who may determine any form and procedure at first. A few more important advantages of arbitration over the state courts: choice of arbitrator, choice of the language of the arbitration proceedings, choice of the venue of the arbitration, the seat of arbitration, choice of applicable law, the norms of substantive law, it will regulate the disputed issue, choice of the arbitration rules. So I believe that these are main advantages of the arbitration and the IDR mechanisms in comparison to the litigation process in the state court.
Great, thanks for that. Now, can you give us some examples of cases that have been solved by the International Arbitration Court with the participation of your company?
It is my pleasure, because I have the honor to participate in the proceedings not only as arbitrator of or the member of the tribunal or chairman of the arbitral tribunal, but also as a representative of the party, where I protected the interests of my own company in arbitration process. And this is another impressions, another feelings, and another professional characteristics to be applied when participating as an attorney, as a party in the arbitration process, and I enjoyed it very much. So the first dispute started in November 2019, and the contract was concluded between our company and the Turkish logistics company. The subject of the contract was the transportation of the cargo from Ankara, Turkey, to the Chara deposit located in Chatkal, Jalalabad Oblast in Kyrgyz Republic. As the carrier violated terms of the contract, our company filed a claim to the International Arbitration Court, demanding to recover from the carrier in favor of our company reimbursement of losses due to damage of the cargo and due to the delay in delivery, and a penalty for the late performance of the services. Consequently, the issue of improper performance was addressed to the arbitration court, and the arbitral tribunal was formed. So 8 months lasted, and finally the arbitration tribunal was formed. There was the international arbitrators, one from Kyrgyzstan, another from Kazakhstan, and they elected the chairman of the tribunal from Ukraine. International tribunal, so parties agreed also to apply ABA rules on provision of evidences. It is a worldwide soft law document developed by the group of professionals in the field of arbitration. The award was granted in 2021 in favor of our company, but the defendant refused to execute it voluntarily, and we had to turn to the State Court of Turkey for the forced execution under the New York Convention. We hired a Turkish law firm, and as under the civil law of Turkey, only Turkish attorneys may represent interests of foreign companies in the national courts of Turkey. Fortunately, after the first hearings, defendants' party suggested to close the issue by amicable agreement, and they paid us all the amount, excluding penalties. And another interesting dispute was with local company, with the self-administration of Chatkal district, that was local authority who filed claim against the company in order to get payment for the lease agreement. The rent included all applicable taxes and fees established by the tax code, by the legislation. And according to the lease agreement, the claimant independently pays the tax in the manner prescribed by the law. The company is not a land taxpayer, and accordingly, the company is not a payer of the penalties for the tax accrued by the state tax service. Fortunately, amicable agreement was reached and approved as the arbitral award finally, and the amicable agreements approved in the form of arbitral award is another advantage for the winning party, as in case if the defendant refuses to fulfill the agreement voluntarily, it may be executed per the procedure of the forced execution, as the amicable agreement is equal to the arbitral award, because it is approved in the form of the arbitral award. So these two interesting cases which I enjoyed as a party in the arbitration proceedings.
Thank you for that. That was really interesting. Now, let's talk about the pandemic. During and after the pandemic, was there any impact on the number of arbitration cases to resolve? And also, in the way the arbitration court conducted the arbitration procedures, was there any difference? Did you notice anything?
Our arbitration institute, I would like to note, very quickly transformed its activities in the mode of online hearings with the participation of arbitrators, parties, questioning witnesses, arranging cross-examinations. Probably there was some difficulties, but I believe that we managed this problem and we provided services. We continued to provide services in online mode during the pandemic. The statistics of the arbitration court of Kyrgyzstan shows that the pandemic has not affected either the number of cases or the timing of the consideration. And all these changes lead to interesting trends. On the contrary, according to my observations, it has become much easier for the parties to make an appointment of foreign arbitrator, since this will not entail additional costs and will not affect the timing of the case. This opens up opportunities for qualified international arbitrators from different arbitration institutions all over the world, including from Central Asia countries, to be appointed or elected to proceedings under the rules of our court, since the common heritage of the unified legal system allows them to freely navigate in neighboring jurisdictions. Conducting hearings online in many cases saves a lot of time and resources for all participants in the process. And yes, there were problems, of course, that didn't exist before. For example, different time zones, technical issues, new organizational aspects, etc. But they were not great huge problems, and the court with its destiny managed to solve all issues, and they continued to provide services in that difficult times. The pandemic has also benefited international arbitration institutions and arbitrators, and this positive effect, I believe, will only increase. All these novelties have made alternative dispute resolution mechanisms more convenient and flexible, and also increase their competitiveness in the long term. In 2020, in 2021, the changes were included into the applicable rules of the International Arbitration Court of Kyrgyzstan, allowing to conduct online arbitration hearings.
Thank you. Now, can you tell us what are some of the challenges facing the International Arbitration Court recently?
Of course, there were sanctions, and we have a lot of issues arising around which led to the conflicts of interests, and some issues related to the ethics of conduct. But all these challenges, from another point of view, allowed us find new ways and opportunities to overcome these barriers. I believe it is another interesting and fascinating and urgent topic, and it requires much more time, and I believe it deserves separate interviewing.
Possibly. All right. Now, let us look at what is happening in this world right now. I mean, 2023, it started off in a very interesting way. There was a lot of global uncertainty. In fact, some people still feel uncertain about their businesses and the way the world is going. All this is brought on by the inflation, recession, and the current geopolitical tensions. Now, we are heading into the third quarter of 2023. Give me your opinion. Do you see any light at the end of this tunnel?
I would like to say that yes, we are going through many difficult times that create challenges on each stage of development. But I believe this also creates some good things for the future development, and also for alternative dispute resolution mechanisms as well, as this is the personal choice and the neutral form, I believe, and maybe more preferable for parties who chooses these mechanisms for resolution of disputes. On the other hand, arbitration is, as I mentioned before, is quite flexible, and it has allowed us to quickly adapt to such difficulties as we managed, for example, during the COVID-19 pandemic and during the sanctions periods. And given this, I am very optimistic about the future development of arbitration and other IDR mechanisms in Kyrgyzstan and all over the world, because it will create only the future opportunities, the future discoveries for arbitration and IDR.
Right. Thank you. Now, for our viewers who are not in this industry, who come from various industries, can you break it down for us? Maybe briefly explain, how does the international arbitration process work from inception to completion? If, let's say, I were a business entity that wishes to resolve my dispute, how do I seek assistance from your institution?
International Arbitration Court itself doesn't resolve any dispute. All disputes came to ICA are resolved by arbitrators or mediators or a panel of arbitrators in accordance with the applicable rules chosen by the parties themselves. The task of the arbitration institution is to ensure the application by the arbitrators of the rules chosen by the parties, as well as to create favorable conditions for the arbitrators to conduct arbitration proceedings. And as noted earlier, the supreme governing body, the Supervisory Board, consisting of now 9 people, including 3 international arbitrators, and permanently including the member of the Chambers of Commerce and Industry, and all of them are well-known lawyers in the Kyrgyz Republic. They permanently oversees the proper performance and rendering by the arbitration courts its services, whether on arbitration or mediation. As for the addressing to the arbitration court, it is easy because the active information activity of the arbitration court allows lawyers and business circles freely get the office of the International Arbitration Court and website of the arbitration court, where all detailed information and exhaustive information on IDR services provided by the International Court of Arbitration of Service of Kyrgyzstan can be disclosed, and each party can reach and see everything. We have also internet bot answering any questions related to the dispute resolution in Kyrgyzstan. And on the websites also there is an opportunity where the parties by themselves may even calculate the amount of the arbitration fee, the registration fee. They could see the exhausted information on each arbitrator include or mediator included in the list of arbitrators or mediators to find proper information to clear up the field of professional activities of arbitrators and elect and choose those candidates to whom they trust. And also read carefully all the rules, procedures, and we also publish the practical activity of the arbitration court and the professional literature and the list of bibliographies, and also all news, all events on improving the qualification of lawyers in the field of arbitration. So a lot of activities towards popularization of the arbitration and the mediation in Kyrgyzstan. Arbitration court also actively provides every time, so by means of educational seminars, international conferences, educational trainings, by conducting moot courts for students, so for the law institutes, for the businessmen, and for those who desire and for those who choose the alternative dispute resolution mechanisms.
Saltanat, thank you so much for that. We have come to the end of this interview. Thank you for taking the time to be with us today.
That was a great pleasure for me. Thank you. And I enjoyed to share share information about the arbitration and IDR mechanisms in the Kyrgyz Republic.
Thank you very much. I believe our viewers will find this information that you have shared very, very useful. Now we know information about the Kyrgyz Republic, and we also know information about the arbitration process in the Kyrgyz Republic. We have come to the end of this really insightful discussion with Ms. Saltanat Imanova, the chairman of the Supervisory Board of the International Arbitration Court, in affiliation with the Chamber of Commerce and Industry of the Kyrgyz Republic. To find out more details, their links can be found below this video. As always, thank you for watching the Global Business Leader series with the Chamber Guy. Remember to hit the subscribe button and watch more interviews with people who make a difference in the world of business. Till we meet next time, stay focused and stay safe. I'm Francis Michael, and I'll see you soon on the Chamber Guy.